Council, good morning and welcome to the January docket of the Kansas Court of Appeals. My name is David Bruns. I've been on the court since 2011, and on the left side of my screen, I don't know if he'll be on that side of your screen or not, but is the Honorable Henry Green, who is the longest serving member of the Kansas Court of Appeals. He's been on our court since 1993. It's a pleasure to be serving with Judge Green. And then on the right side of my screen is the Honorable Gordon Atchison. It's also a privilege to be hearing cases this morning with Judge Atchison. He went on the court about a year before I did in 2010. This morning, our last case in the docket is a workers' compensation case, Daniel White versus RGV Pizza Hut and Argonaut Insurance Company. I would ask that each attorney state your appearances for the record.
Your Honor, on behalf of the appellant, Kip Cuban appears on behalf of RGV Pizza Hut and Argonaut Insurance Company.
And Your Honor, on behalf of the claimant, Brian Pistotnik appearing. Thank you.
You. And Mr. Cuban, as you know, there's 15 minutes argument. Would you like to reserve any time for rebuttal?
I would like to reserve 3 minutes if I could, Your Honor.
That is fine. You may proceed.
Thank you. Today, Your Honor, Kip Cuban appears on behalf of RGV Pizza Hut and Argonaut Insurance Company, its insurance carrier, as the appellant in this matter. We're seeking relief from a ruling of the Kansas Workers' Compensation Appeals Board, which held that the claimant, Mr. White, was a statutory employee and hence eligible for benefits under the Kansas Workers' Compensation Act. As I'm sure the court has read the briefs in this matter, I'm not going to spend particular time on the factual basis other than to say that the claimant suffered an accident in Brownsville, Texas, where he fell from a roof in November of 2017, injuring his leg. The relationship between the parties were RGV Pizza Hut, who was a franchisee of Pizza Hut Corporation, which ran pizza restaurants in the states of Texas and Oklahoma. They had requested the help of a Daniel Schomburg. I'm not sure I had the first name right, but Schomburg Incorporated, to power wash and paint roofs of its restaurants. And Schomburg, in turn, according to the facts that were found by the administrative law judge, retained an employee, Daniel White, to assist him or to conduct the work in power washing and painting those roofs in Oklahoma and Texas for RGV Pizza Hut.
Let me ask you two preliminary questions to make sure I understand correctly. Did RGV Pizza Hut retain Schomburg on a piecemeal basis, or retain for a length of time to paint or do whatever to all of its shops?
I think the record will reflect that RGV Pizza Hut dealt with several painters, but from time to time would engage Schomburg Incorporated to do work on some of its restaurants. This was not something that had to be done all the time, but was done on a periodic basis.
And then my other question would be, just other than potentially contracting with a Kansas business, did RGV Pizza Hut do any other business in the state of Kansas?
No, Your Honor. The record would reflect that it only did business in Oklahoma and Texas, where it had pizza restaurants. The appellant seeks relief on 3 different grounds. The first ground is that the claimant failed to establish facts which would indicate that the claimant was a statutory employee under Kansas law. And that would be under the statutory authority of KSA 44503 and its interpreted case law. Most notably, the Hanna case sets out the test for statutory employment. The second ground is that the Kansas court, or in this case, the Kansas Administrative Agency, did not have personal jurisdiction over RGV Pizza Hut, who was a Texas corporation, which should have engaged the administrative law judge and the board to engage in an analysis that was set out under Abbey versus Cleveland inspecting, where the court first determines whether or not there's a statutory basis for jurisdiction. And if it does find a statutory basis for jurisdiction, then has to engage in the second part of the analysis as to whether or not the employer and its insurance carrier have sufficient minimum contacts with the state of Kansas, which would comport with the due process requirements of the United States Constitution. And the third element or the third ground we seek for relief is that this case should have never gone to a final hearing at all. But under the requisites of KSA 44-523 subsection F, subsection 2, the court was mandated to dismiss this matter in April of 2018 based upon the statutory requisites of that statute. Going first to the first ground that we've alleged, the one of statutory employment, the first issue that becomes apparent is whether or not, or the parties disagree on what the appropriate scope of appeal is or scope of review is. The respondent submits that the appropriate scope of review is de novo, based upon the fact that the facts are not in dispute, but rather whether those facts as established by the administrative law judge, but ultimately the board, are sufficient to satisfy the legal requirements that are set forth in 503 and its interpretive case law.
Before you move on that, I wanted to ask you about standard of review. And I understand that the basic facts here are evidently not in dispute, but at least in a normal case involving statutory employment, wouldn't this be a mixed question of law and fact? For law, what's the statute say? What are the factors for statutory employment? Facts being, do these facts match those requirements?
In your normal case, there would probably be a mixed element. However, that mixed element does not really appear in this case because the facts really aren't in dispute.
Okay.
So it's simply on the mixed matter of law and facts, the facts are not in dispute.
But you're saying statutory interpretation is a question of law. Unlimited. Right. Okay.
So in going to the statutory employment, that's set out under KSA 44-503, and the test for that is set out in the case of Hannah, which is discussed at length in both of the briefs. In the Hannah case, basically there are two steps or a two-part test to determine whether or not the claimant in this case would be a statutory employer of the principal when the subcontractor is not liable under the Workers' Compensation Act. The first of those is the one that's really in dispute. The first element of the test can be satisfied by either showing that, number one, the claimant was performing a part of the business or tasks that were inherent to the business of the principal, or the second element of that is that the claimant was performing work that was normally done by the principal's employee. I don't think there's any serious dispute that the second test cannot be met by the claimant. The record is uncontroverted that Pizza Hut, RGV Pizza Hut, did not have people who did roof washing or painting, nor did it have departments of industrial painting, nor did it own any equipment that allowed its employees to do that. In fact, I think that the record would reflect that Pizza Hut, RGV Pizza Hut employees were not even allowed up on the roof of their restaurants. So we're really focused on the idea of whether or not the washing and cleaning and painting of roofs is an inherent part of the business.
Now, let me ask you a preliminary question to that. I assume based on the name that RVG operates only Pizza Hut restaurants. Is that correct?
Actually, I think the record does reflect that it did also have other franchise restaurants that were not Pizza Hut restaurants. But again, I didn't specifically look at that, but my recollection of Mr. Wicker's testimony is that they may have had other franchise restaurants for other franchisors other than Pizza Hut.
Okay, but the work at issue here that Schaumburg was hired to do was all on Pizza Hut restaurant.
It was.
Okay, and so to the extent that we're looking at an underlying agreement, the franchise agreement between RVG and Pizza Hut would be the controlling agreement for that purpose.
Well,
in other words, they weren't out working on some other franchise restaurant. They were all Pizza Hut restaurants.
They were working on Pizza Hut restaurants, though I'm not sure that I agree with the court when it says it's the controlling document, because I think there's an issue in there as to inherency of the tasks and what a business has to do to maintain its franchise.
Okay. To the extent that there is a written document governing the franchise arrangement between RVG and Pizza Hut, that's the controlling document.
Yes, RGV Pizza Hut is operating under the franchise agreement with Pizza Hut.
All right. I'm sorry. Go ahead. Explain why the RVG is not a statutory, or RGV is not a statutory employee.
Well, RGV is not a statutory employer of Mr. White because the tasks that were being performed by Mr. White are not inherent to the business operation of RGV Pizza Hut. It's clear in the record that the purpose of RGV Pizza Hut and the business of RGV Pizza Hut is selling pizzas, operating pizza restaurants. Now, the fact that Pizza Hut Corporation, it's a franchisee of Pizza Hut Corporation, is really irrelevant to the inherent nature of the business. The fact that it could also have been a franchisee, or it didn't have to be a franchisee at all to perform the inherent task of the business, which was to operate and to sell pizzas to the general public and operate a pizza restaurant. The fact that it chose to be a franchisee does not have anything to do with the inherent work that corporation does or the inherent purpose of that corporation. Could have just as easily been a pizza restaurant that was not a franchisee of Pizza Hut or a franchisee of some other corporation. So it's not an inherent aspect of their business that it be a part of, that it be a franchisee of Pizza Hut to perform the task of the business. And the interpretive case law on this issue, on the first prong, if you will, of the Hanna test, I think is instructive when you're looking at this situation. And I would point to the Rowan case where Judge Lundstrom has a discussion of the Hanna test in connection again with a case that comes from the other side of the aisle, a civil case where they're attempting to, where the statutory employment is being used as a defense. But the court was fairly clear, and Judge Lundstrom's interpretation, I think, persuasive, if not precedential on this court, that it has to be more than just something that's necessary or even indispensable, because as the court notes in that discussion, that would be descriptive of any type of repair work. It has to be something that goes to the core as to whether or not the business can move forward if those tasks are not being done. And in this case, even if Pizza Hut would have pulled its franchise from this particular business for failure to adhere to the requisites of the franchise commitment, that would not have stopped the business from selling pizzas or running a pizza restaurant. So the fact that it's a franchisee is not inherent to the nature of the business. Moreover, the court's really considered this in prior cases. If the court looks at the Rodriguez versus John Russell construction case, a similar argument was made that dealt with the city of Garden City, Kansas, who hired John Russell Contracting to perform maintenance work on a HUD project in Garden City. In that case, Mr. Rodriguez was injured while working for John Russell Construction. They were not subject to the Workers' Compensation Act, so a claim was pursued against Garden City based upon the theory that since they had to operate using the HUD guidelines, that somehow made it an inherent part of their business to do maintenance on the housing project. The court rejected that in that particular case. The concurrence in the board decision also, even though the administrative law judge did not find this, indicated that it could be covered under what we would call a Harper theory, and that is contracting out a contracted for service. And in this case, that doesn't fit the facts in this case either. For example, if Judge Bruns, or if I hired Judge Bruns to build a garage in my backyard, and he then in turn hires Judge Green to build my garage in the yard, and an employee of Judge Green's is injured and Judge Green is not subject to the Kansas Workers' Compensation Act, the claimant might be able to pursue a case against Judge Bruns because he specifically contracted to perform a service and then completely delegated that entire service to somebody else for whatever reason. But the statutory policy behind this is to prevent people from getting out from under its workers' compensation liability by simply taking a contract and then giving that contract to someone else who may not be insured. That's not the case in this situation because Pizza Hut did not, or RGV Pizza Hut did not contract with Pizza Hut Corporation to clean and paint all of its roofs for all franchisees across the United States and then somehow delegate that out to Schaumburg. In this case, the cleaning work, the work on the roof was tangential to, not inherent to the business of Pizza Hut or RGV Pizza Hut.
And Mr. Cuban, you're at, well, just about 15 minutes now. So if you want to save a little time for rebuttal, I'll give Mr. Postotnik some extra time if he needs it, but you might want to go ahead and wrap this portion up.
I think that is really the issue that is most prominent. The other issues are discussed fully, I think, in the appellant's brief and the reply brief of the appellant. So I would defer now to Mr. Postotnik and then reserve the rest of my time for rebuttal. Thank you, Your Honor.
Any other questions from the panel for Mr. Cuban? Mr. Postotnik.
Thank you, Your Honors. May it please the court. When you look at KSA 44-503A, what you really have are three possible ways to become a statutory employee. The statute itself talks about two of those tests. First is whether it's part of the principal's trade or business. And of course, that gets extrapolated by the Hanna case and the Bright case into the other two parts, which are whether it's necessarily inherent in and an integral part of the principal's trade or business, or ordinarily done by the employees of the principal. And then, of course, back to 503A, the third test is whether it's contracted to perform. And in this case, we concede that this is not the type of work which was ordinarily done by employees of the principal. But in the board decision, the main decision basically made a fact finding, and that fact finding was that maintaining roofs on Pizza Hut buildings for a national Pizza Hut franchisee was a part of the principal's trade or business. In the concurring opinion, one of the board judges basically confirmed that there was also a contract to perform. And so basically under both tests, we end up being a statutory employee. Mr. Cuban's right. The facts in this case, as far as what happened, are not in dispute, but I would submit the facts are completely in the favor of the claimant. During Mr. Wicker's deposition, he basically confirmed that maintaining the roofs, painting the roofs, that was integral to the business. And that was actually one of the primary parts of the business, was keeping the business, not only the inside food and the decoration, but the outside of the buildings to be up to Pizza Hut's national standards. Because if they weren't kept up to those standards, Pizza Hut would come in and perhaps close them down.
What is your response to Mr. Cuban's argument that really the business properly defined is making and selling pizzas, and how the roof is painted or maintained is not an integral part of making and selling pizzas?
And I think the big difference is whether you're looking at a mom and pop shop that's cooking pizzas down the street, or whether you're looking at a national franchise. We're dealing with a national franchisee that's got hundreds of restaurants. And they've got to not only build the restaurants, they've got to maintain the restaurants, they've got to make sure the appearance meets national standards, or they're not pizza anymore. Instead of having a large business based on a national reputation, they're a mom and pop shop. And like I said, if Pizza Hut were to shut them down, that's not good for a franchisee. And I think what you got to look at is this is a franchisee, not just a singular mom and pop shop.
Counsel, how is this different than, let's say, a hotel chain, which we've often seen, I'm sure, in Wichita, and I know I've seen it in Topeka and Kansas City, where I'm just hypothetically, it's a Marriott, it doesn't meet those standards. It remains a hotel owned by the same exact people, and it next becomes a Holiday Inn until it can no longer meet those standards. And then it becomes a Ramada Inn, then it becomes a Best Western, but it continues throughout to be a hotel serving people who are traveling. How is this different than that? I mean, it seems like even if you lose the Pizza Hut label, can't you still keep making pizzas?
You can, but you're not part of that franchisee. And I think what's important here is the law. When you look at the Fugit case and the Seba Geige case, it doesn't have to be the primary thing of the business. It just has to be part of the business. And the actual wording of the
statute. Well, does it have to be part, or does it have to be an inherent part?
Well, the statute itself says part. And the wording is part of the principles, trade, or business. And then the Hanna test says it's necessarily inherent in and integral to the business. And that's where Wicker's testimony is important, because he says it is.
But we're bound by Hanna, are we not? I mean, Hanna, the Supreme Court may want to change Hanna. I mean, that's an old case. But as we all sit here today and have to deal with these types of cases, we're bound by Hanna, are we not?
Yeah, no, I agree. And Hanna basically is favorable for the claimant, because Wicker says that this work of maintaining the roofs is integral to their work as a franchisee for Pizza Hut.
Now, but is that the same thing to say that it's integral to maintaining my franchise? Is that the same thing as saying it's necessarily inherent to my business? I mean, they're making the argument our business is making pizza, and whether we'd hate to lose that franchise, but if we did, we'd keep on making pizzas.
Well, and then they probably could. They could get a franchise with Papa John's or some other pizza group. But if they do, they've got another contract. And of course, then you got to look at the franchise contract, which basically sets forth that Pizza Hut contracted with RGV to build Pizza Huts, to maintain Pizza Huts. And by contract, RGV are doing these things for the third party. The third party is Pizza Hut. And then RGV, what you got to look at is they're hiring somebody in Kansas to come down and paint Pizza Huts in Texas. And by hiring a subcontractor, and by not checking that subcontractor to see if they have work comp insurance, they're basically trying to evade work comp. And Kansas is protecting the Kansas workers. The Rodriguez case talks about that. The legislature, by statute, desired to protect employees of irresponsible and uninsured subcontractors by imposing ultimate liability on the presumably responsible principal contractor who has the ability to ensure appropriate compensation for its workers. And that's really where RGV went wrong. They shouldn't have hired a Kansas subcontractor without getting proof of work comp coverage.
But that's not the test, is it? I mean, that's not. I mean, I understand that that's a good policy argument for the legislature, but we have to look at whether it's a necessarily inherent part of the business, and it may or may not be. But the fact in 2020 hindsight, we can't figure out what their underlying motivation was.
Right, and again, I think you've got to look at RGV not as a pizza restaurant; it's a franchisee, and that's the important thing here. They're not.
Let me ask I'm going to display my ignorance of work comp law, and Mr. Cuban can already attest to that. But in this case, there has been obviously no award made. Does this get remanded to litigate that, or is there some agreement as to what Mr. White would get if, in fact, RGV is responsible here?
And that's a very good question. When the board issued its decision, Judge Marchant started working on preparing an actual award, and then Mr. Cuban objected that. So I do believe this case has to be remanded back to Judge Marchant to actually issue the award stating what benefits the claimant receives.
Okay, and is there evidence in the record to have that done? I mean, it simply goes back. Do you guys get to argue about that, or is there more evidence, or is it simply require an award?
Yeah, I don't
be fashioned from what's in the record. I'm sorry.
I don't believe there's any additional evidence. I just think she has to go back and say, okay, now that this is compensable, here's what the claimant gets.
Okay.
So, and then I guess the other important thing about Rodriguez, Kip respondent has argued all along that Rodriguez helps his position, but in fact it doesn't. In Rodriguez, the claim was found to be compensable, and Rodriguez is very similar to our case. City of Garden City operated housing for HUD, and operating housing doesn't mean just renting to people. It means maintaining the buildings and make sure the buildings are fit for occupancy. And of course, in the Rodriguez case, they found that it was inherent in the business to maintain those properties, just like a franchisee has to maintain their buildings. So we believe the Rodriguez case actually supports the claimant. As far as the contract part of that, the court actually said there was no evidence in the record of a contract between HUD and Garden City. They didn't say that it didn't imply, they just said that there wasn't any evidence of that. Now, I would like to talk about the other two issues just briefly. The respondent talks about the Abbey decision. And the Abbey decision, again, supports the claimant, because in Abbey, what happened was someone had contacted a Kansas worker, hired the Kansas worker by phone, and ultimately the decision was the employer was subject to the Kansas workers' compensation laws, even though Cleveland, the employer, never did work in Kansas. Even though there was no Cleveland coming to Kansas or doing anything in Kansas other than making the contract of employment with the worker. Now, the holding having to do with no jurisdiction was only for the insurance carrier. And the insurance carrier did not do business in Kansas at all, had never been to Kansas, and had no contract in Kansas. And that's why in that particular decision, the employer had to pay work comp, but the work comp insurer did not. But there was still a legal liability for the employer in that case, just like there is in this case. And of course, our case is different. Argonaut Insurance is doing business in every state. They do business in Kansas. But Kip never made the arguments that they did not do business in Kansas. So I guess that's kind of a moot point. And then the third issue, of course, is whether or not this was pursued timely. Mr. Cuban has argued there's no evidence in the record. And I would submit that there's substantial evidence in the record about what transpired after the initial preliminary hearing, up through the time the second preliminary hearing was done, up through the time that the final award was issued. But Judge Marchant did make a fact finding, basically that the claimant had just cause for not doing it within 1 year, because there was no delay. During that whole time frame, the claimant was actively litigating the case. And there was a lot of delay in getting an out-of-state witness. There was concerns about a protective order by one of the other parties. But this case was actively being litigated in front of Judge Marchant that whole year. And so Judge Marchant extended the time frame to go to regular hearing, and we got to regular hearing within the time frame that Judge Marchant had indicated. I think we beat it by 1 day. But in the work comp system, it's very difficult to get to a regular hearing, because to get to a regular hearing, you have to prove that your claimant has reached maximum medical improvement. And when a claimant gets denied, like this case, he has no way to even get treatment or have a doctor determine he's at maximum medical. You have to go to a pre-hearing settlement conference before you go to regular hearing. And so you got to follow all these steps of the work comp laws. The ALJs won't let you schedule a regular hearing until you have proof of a permanent impairment rating. And of course, getting the claimant into a doctor, getting a report, scheduling a pre-hearing settlement conference, going back to court again, all these things take a lot of time, and sometimes respondents don't cooperate with that. In fact, the record has evidence of Mr. Cuban kind of fighting each step of the way. I'm not going to allow you to do my deposition. I'm not going to allow you to do my deposition by phone. We had multiple hearings on all these issues all along the way. And I'd be happy to answer any other questions the court would have today.
Any other questions from the panel? Thank you, Mr. Postotnik.
Thank you.
Mr. Cuban, would you like a couple minutes for rebuttal?
Thank you, Your Honor. Just a couple of follow-ups to the last statements from counsel. First of all, I think Judge Bruns really hits upon the issue in the first request for relief on statutory employment, and that is there's a difference between necessary or indispensable and inherent. Inherent really means that you cannot do the business absent those tasks. And as Judge Bruns points out with the hotel example that he gives, hotels continue to go on and on whether or not they are franchisees of any particular business or not. In this case, RGV Pizza could have continued to make pizzas even if they were no longer a Pizza Hut franchisee, and could have continued on with the business. It would not have stopped their business not to have painted the roof. And moving on to the second element of jurisdiction over RGV Pizza Hut, I think Mr. Postotnik misinterprets the importance of the Abbey decision. The Abbey decision stands for the proposition that even if the contract of hire between the purported employee and the subcontractor takes place in Kansas, that does not bind other people to the Kansas law or give the Kansas courts or administrative agencies jurisdiction over those parties that were not subject to that contract that was entered into in the state of Kansas. In this case, there is no evidence that there was any contact between Mr. White and RGV Pizza Hut in the state of Kansas, nor any partial performance of any job duties or anything like that, which would indicate that there's a statutory basis for jurisdiction. But even assuming arguendo that there was a basis for statutory jurisdiction, the court then has to go on to the second element of the test, and that is whether or not there were sufficient minimum contacts to purport with the 14th Amendment of the United States Constitution. And neither the administrative law judge nor the board engaged in that analysis. So on that ground alone, it should be remanded for a review of that particular issue. Finally, on the issue of dismissal of the claim, again, since Casco, the court has taken a position that it's going to specifically read the statute. The specific statutory language is explained in the brief, entitled "The Respondent to Dismissal of the Claim," and statements of counsel as offered by the claimant at the hearing on the motion to dismiss are not sufficient based upon Kansas case law. The fact is clear under case law that statements of counsel is not proof, and the statute specifically requires proof. So, unless there are any other questions from the panel, I
do have a question on your the last issue. We've kind of put that one on the back burner a little bit, but the ALJ specifically ruled, quote, "After reviewing the evidence, the court finds that White has met his burden to prove that he had a good faith reason for delay pursuant to KSA 44-523F2 in not proceeding to regular hearing within 1 year of the January 30th, 2017 order, period," close quote. And it goes on from there to say some of the evidence that the ALJ at least believed was sufficient. What's our standard of review there? I mean, we aren't the fact finders. And if the ALJ heard the facts and decided that he met his burden, should we be replacing our judgment for that of the ALJ? And if so, why?
No, but that's not what we're asking you to do, Your Honor. We're asking you to determine whether or not there was any proof at all submitted at that hearing. The only thing that was offered were statements of counsel, and I think the Kansas law is abundantly clear that statements of counsel is not evidence. The statute under 523F subsection 2 requires proof, not statements of counsel.
Okay, well, I'll have to look at that because I thought the ALJ did then give a justification for that finding, but the record speaks for itself on that.
The
Any
record
other
does speak
questions
for
from the,
itself.
any other questions from the panel? If not, thank you both. We'll take this case under advisement and get a opinion out to you, hopefully in a timely manner. And with that, we thank you both, and we will adjourn this session of the Kansas Court of